Bien, en attendant, nous faisons le grand bond vers le Japon avec la professeure Yuko NISHITANI, professeure à Kyoto, qui va donc nous parler de la codification française vue de l'Extrême-Orient.
Merci beaucoup. Alors, merci beaucoup pour votre invitation. Je suis en fait maintenant à La Haye, en Europe, mais je participe à une réunion de la conférence de La Haye. Alors, je m'excuse de participer à cette conférence en ligne. Et je m'excuse aussi de faire ma communication en anglais parce que je suis un peu hors pratique de français. Alors, je vais parler en anglais. Merci beaucoup. So, the talk I'd like to give is about the French codification, and this is the outlines I'd like to give you about my talk. Okay, so the first French codification on private international law is Article 3 of the French Civil Code from 1804, and it already had an innovative rules, namely loi de police, and the application of lex récite of immovables, and the application of French law to French nationals. And these innovative rules were evolved in other European countries and accepted and further developed. And when Japan adopted our Private International Law Act in 1898, we very much relied on the French codification and also later development in French case law through Gustave-Émile Boissonade de Fontarabie, who was invited to consult our legislation. After that, and even after we adopted our own statute on private international law, we closely followed the developments of French case law because it's very innovative and was very inspiring to us. And after the European Union started to adopt different regulations, I think France and other European member states were a little bit hidden under the European regulations, but it remained certain difficulties for third states, including Japan, particularly the jurisdiction based on French nationality, Article 14 and 15 of the Civil Code, is, in our eyes, an exorbitant jurisdiction. So if French plaintiffs go to the French court and the Japanese defendant has to respond to the process, we have difficulties. And in Japan, can be recognized in France or not, that's also not easy to answer. And then after the European Union adopted different regulations as piecemeal legislations, it became also difficult for us to detect what are the relevant rules. From that perspective, the French draft private international code from last year is a very good step forward because it entails different clear-cut rules and ensures legal certainty and predictability. And it can be very well a model from a comparative perspective. About the general principles adopted in the French draft codification. So first of all, it is obvious that these rules will facilitate law application for judges, practitioners, and citizens in my eyes. So this draft codification has various references to the EU regulations and conventions of the Hague Conference that will facilitate to detect what kind of rules should be applied in certain situations. Certain loopholes I detected are, for example, that when a 1980 Child Abduction Convention is applicable, when a child habitually residing in Japan is wrongfully removed to France. And in such a situation, France is supposed to return the child immediately to Japan in principle, and the custody jurisdiction is given to Japan. And in such a situation, because Japan is not bound by the 1996 Hague Convention on Child Protection, we do not have any specific binding rules with France. So in such a situation, perhaps it may be helpful for the French codification to have a specific rule providing for the custody jurisdiction to Japan in this situation. Similarly, in relation to 1993 Inter-Country Adoption Convention, this draft codification designates law of nationality of the adoptive parents of the child, respectively, and partly the French law is applied based on nationality. And in certain situations by domicile. And the 1993 Inter-Country Adoption Convention actually requires also that law of the habitual residence be respected, namely in a situation where child is habitually residing in state A and adoptive parents are residing in state B. There is a cooperation between the central authorities, and they check according to their own laws, respectively, whether the child and the adoptive parents fulfill conditions for adoption. So through this way, partly the law of habitual residence needs to be respected, and this may be also a point that could be mentioned in such a codification. I also find it quite interesting that there are certain differences from the EU regulations in Eurodraft codification in France. So, for example, as Gianpaolo also mentioned, the primary connecting factor is nationality, unlike habitual residence in EU regulations. And also party autonomy is very much accepted in the EU regulations, and this is rather limited to French law in the French codification in relation to name and extrajudicial divorce. I also find it quite interesting that we can observe the extension of EU rules in your French codification, draft codification. So Rome I regulation and Rome II regulations are extended to other cases excluded from the regulations themselves, and you have a specific rule on the applicable law for defamation as well. And the so-called principle of recognition of the European Union of the situations established abroad for status matters, particularly the name, and is also extended to other cases in relation to third countries. So that's also a notable characteristic of your draft codification. With regard to the authority of the judge, it is notable that you have ex officio application of international supranational instruments added for. At the same time, you still maintain accord procedural and the parties' obligation to inquire and to make specific inquiry in certain situations. And Article 130 provides for that parties need to invoke and prove the content of foreign law. So there is a task division between the judge and the parties in concrete procedures in order to apply foreign law. And this is an interesting way of striking a balance between the judge and the parties. At the same time, from a Japanese perspective, we would rather have concern whether the uniformity and certainty of law applications could be guaranteed under these rules. So we do have an ex officio application of foreign law in Japan, and it is left to the task of the judge. So I wonder to what extent in France the certificat de coutume, which is often used to ascertain the content of foreign law, would help to facilitate the task of the judge and possibly also the duty of the parties to prove the content of foreign law. When it comes to the application of foreign law, China has an interesting provision in its own statute on private international law. So it is provided for that judge has the ex officio duty to apply foreign law, but parties have the task of proving foreign law when party autonomy applies. So to the extent that the choice of law is allowed, parties need to prove a foreign law themselves, and they try to strike the balance between the judge's task and the party's task by that way. And in reality, actually, China rarely applies foreign law. So in 96% of cases, it is Chinese law that is applied, to my knowledge, because judges often refer to public policy or overriding mandatory rules of Chinese law. But still, that's the provisions they have in China. When it comes to status and family matters, it is interesting to see that you have in your draft provisions renvoi in Article 8. So if we consider that you follow the principle of nationality in your draft codification, you will probably have quite a number of cases where you will have renvoi and have to refer to the conflict of laws of a foreign country. And it is explained in your explanatory report that that should facilitate law applications. But if you have to apply a foreign conflict of laws rules to see whether French law is designated by the foreign country, it may not be so easy in every case to apply renvoi provisions. When it comes to principle of nationality, it is interesting that French draft codification still sticks to the nationality as the connecting factor. French nationals living abroad will then continue to be subject to French law. At the same time, immigrants living in France, immigrants living into their law of home country. De facto, because France has a jus soli principle for the acquisition of French nationality, in many cases, immigrants living in France do have French nationality. However, the first generation of immigrants coming from abroad would still be subject to their national law, which is a foreign law in such a case. Japan actually continued to follow the principle of nationality because we have in many cases legal acts that is conducted before the civil registry. So traditionally we have consensual divorce, which is also the case with France nowadays. But because our civil registrars do not have any authority to conduct substantive investigation, we thought it would be very difficult to use habitual residence as the primary factor. So this is why we have kept our nationality and also respecting cultural identity of foreigners coming to Japan. I did some comparative research, and actually there are so many countries, as indicated here in my slides, that still follow the principle of nationality. So this is why, of course, there are many countries in Europe that now follow the principle of habitual residence, but still there is a large group of countries that still follow the principle of nationality. When it comes to connecting factor, I found it interesting that you have also the notion of domicile in your draft codification. When Japan adopted our private international statute in 2006, quite recently, we abolished the notion of domicile to determine the applicable law because we thought we should unify everything with habitual residence according to the Hague Conventions and also the international trend. So this is why I checked what kind of definitions you use for domicile and habitual residence, and certainly you have good reason to have two different notions, but that would be also an interesting point to know how this will develop in France and how we could possibly also examine and follow the French approach in this respect. And with regard to the recognition of the situations established abroad, you have different provisions that provide for this possibility. So involvement of foreign authorities is required to recognize the situations established abroad, and the approach of recognizing foreign administrative acts as such is quite innovative and different from Germany or Japanese way of thinking, because, for example, name or marriage, that would be considered as legal acts of private parties in our legal systems. So this is why we would just apply the usual conflict of laws determining the applicable law, and we would not follow the recognition of the situations established abroad. And that would be different approaches. And again, I'm personally very much interested in the French way of seeing these possibilities and different methods, and rather recognize directly the situations established abroad insofar as foreign authorities are involved. I'd like to move to the civil and commercial matters. What I found interesting about the draft codification of France is that a jurisdiction based on nationality is still used. So the explanatory report says that it envisages the protection of foreign French nationals, and this is of course extended to other EU member states citizens on grounds of equal treatment. So this is why when the plaintiff has a French nationality or German or Spanish nationalities, they can come to French courts and institute court proceedings against a Japanese defendant domiciled in Japan. So opening the forum may be important for French or EU citizens in such a case. At the same time, from the viewpoint of third states like Japan, it is an exorbitant jurisdiction, and we would have concern whether the right to be heard of the defendant can be sufficiently protected. And in such a situation, even if French courts render a judgment, it will probably not be recognized or enforced in Japan for lack of jurisdictions. So in that perspective, will create limping legal relationships, and this kind of exorbitant jurisdictions may entail also certain drawbacks and difficulties in this respect. When it comes to the recognition of foreign judgments, I was surprised and also positively how can I say? Surprised, and also took note of your provisions with interest that you have generous recognition regimes, that you have generous recognition rules, and there are limited conditions for the recognition of foreign judgments, which I find is very good, and that will ensure the circulation of judgments across borders between different countries. And the problem actually we have in Asia with judgments recognition is that we require reciprocity in different countries to recognize foreign judgments. And I saw that in your draft, you do not have reciprocity requirement, which I find is very good. But in Asia, between China and Japan, currently there is no reciprocity, so it's not at all possible to recognize judgments between our countries. And Indonesia and Thailand also require reciprocity based on treaty. And because we do not have any treaty relationship, it's not possible to recognize foreign judgments between our countries. And the situation is similar with Cambodia, Myanmar, the Philippines, and Vietnam, and so on. So it's the difficulty we have. China itself is becoming more open to recognize foreign judgments because it has certified bilateral treaties with different countries. I think France is also included. And reciprocity is now established with South Korea, Singapore, and Australia, and the US, the UK, once the foreign country has already recognized the Chinese judgments. So in order to developed the One Belt, One Road initiative for China. It's very important to ensure the judgment's recognition, which is unfortunately not yet the case with Japan. So in order to overcome these difficulties, I think legislative model like French one is desirable. And also we could also think about ratifying the 2005 Choice of Court Convention or 2019 Judgments Convention to have a framework of cooperation. Other notable conflicts of laws, conflicts of laws rules are you have separate rules on company and based on the law of the statutory seat, which is the place of incorporation. And in Japan, we follow the same principles in our case law, but we fail to adapt specific conflict rules. So it's very good that you have this provision in your draft proposal. And also you have specific rules on trust. And in Japan, we do not have any specific conflict rules on trust, although in our substantive law, we adopted the English system of trust. So it actually would have made sense for us to adopt specific conflict rules. And unfortunately, we failed to do that in our 2006 legislation. So this is why academics are now disputing to what extent we should apply the law governing the contract to trust, and to what extent we should consider the law governing the trust assets. And having specific rules like the French proposal would be a very good way forward. I come to my conclusion. It's fascinating to see what kind of comprehensive and good legislative project you have in France, and I really hope that this can be materialized as a codification very soon. It will be also good to think about coordination with Asian jurisdictions, and because in Asia we have a lot of countries that still follow the principle of nationality, we will have the same applicable law rules in France if you adapt these rules in France. And having also judgments recognition between our countries would be very helpful to have a coordinated legal systems. What is also interesting for us is that extrajudicial divorce that is conducted in Japan will be recognized in France under Article 168, paragraph 2, because you treat administrative acts as judgments, and our extrajudicial divorce is conducted by declaration to the civil registrar in Japan. And before this proposal, I think it was still debatable whether this kind of extrajudicial consensual divorce in Japan can be recognized in France. But after France also introduced extrajudicial divorce, and as this proposal says, it will be facilitated to be recognized in France in the future. Possible future operations with Hague conferences and conventions would be also desirable. And I'm now in a working group on the Hague Conference Parentage and Surrogacy project, and we are now developing an instrument on the recognition of legal parentage established abroad. So if we succeed to adapt this instrument, and France and Japan can join this kind of instrument, that will be very helpful to ensure the circulation of judgments, and also ensure the recognition of legal parentage between our countries. So thank you very much for your attention, and this is the end of my talk. Thank you.
Bien, merci infiniment pour cette intervention. Alors, on retrouve, c'est très intéressant, on retrouve à la fois des questions qui ont déjà été évoquées ce matin, la question notamment de l'office du juge, de la preuve de la loi étrangère, la question du renvoi, la question du maintien de rattachement à la nationalité, même s'il est subsidiaire, donc ce vieux privilège de l'article 14 et l'article 14 et 15. Donc on retrouve ces questions-là, avec bien sûr aussi la question de l'enlèvement d'enfants, qui est actuellement une des plus sensibles dans les rapports entre la France et le Japon. J'en sais quelque chose. Et en même temps, on ouvre notre réflexion à d'autres champs. Et en particulier, c'est vrai qu'on aurait peut-être trop tendance à penser la codification, et notamment la question de l'articulation entre règles codifiées nationales et règles internationales, parce qu'on est dans un réseau, nous, Français, de conventions et de règlements, et donc de penser ces problèmes de droit international de codification trop dans le cadre de ce réseau-là, alors que dans l'intervention de John Paulo, comme dans la vôtre, eh bien, on est amené à réfléchir à des pays qui ne sont pas dans ce réseau. Et ce qui pose des questions différemment, et notamment de l'extension qu'on peut donner à des instruments internationaux, involontairement, en quelque sorte, en s'y référant trop directement. Donc, je pense qu'il y a quelque chose sur lequel on pourrait réfléchir. Ce sera sans doute un élément du débat. Alors,